George Gryllos, Mariya Serafimova, Vivien Terrien, thank you very much indeed for your time and very warm welcome to the Digital Markets Research Hub. I was waiting for this conversation for quite a long time because today we have an opportunity to look at how the European law in general and European competition law and maybe digital proto, quasi, sui generis competition law and policy is being made. So we will discuss the topic with hidden architects of legal DNA of the area. And it's a great opportunity for us to look at competition law maybe more generally as well. So I wanted to start this conversation with asking you, as a matter of reminder, maybe to outline to us the level of judicial scrutiny the Commission of the Commission decisions, because it was always a hot topic, but now in conjunction with discussions in the UK about the level of judicial scrutiny, the Digital Markets Act, UK equivalent, Digital Markets Competition Consumers Bill should have. These problems has been escalated as well. So why wouldn't we start with you, Vivien, reminding to us this issue?
Sure. I mean, just one thing on this first. I'm not sure we are hidden architect. Actually, I think well, I see myself, but I guess, I mean, my colleagues will have probably the same feeling. I mean, we are more little helpers here. And this is basically what we do. I mean, we we just propose, we research, we draft for sure, but it's only a draft, and final decision, final writing is given to the judges. So that's not an architect hidden anywhere in the court. It's just little helper, I guess. But anyway, so that's basically, I mean, we might come back, I mean, to that topic, I mean, at a later stage. You talked about, I mean, judicial review. I mean, in competition law cases, I would say probably, I mean, 15 years ago, the general court was under heavy criticisms, I guess. And I don't think, I mean, today we hear the same voices against, I mean, the type of judicial review we do in competition law cases. I mean, first of all, I guess, I mean, we have to agree that when we review essential procedural requirements, or when we review the right of the defense, there is actually no margin of discretion whatsoever to the administrative bodies. So here, I mean, the European Commission. So you may have seen in Qualcomm, you may have seen in the cargo case, I mean, that we actually annulled, I mean, based on the violation of the right of the defense. So for this, I mean, there is no doubt, no question about, I mean, the level of judicial review, I mean, we apply at the General Court. The second point is about the sanction. For the sanction, again, we do have a specific judicial review, which is a full jurisdiction. And once again, we may not have been very proactive, I mean, some years, I mean, to use it, but I guess, I mean, you've seen Android or other cases, I mean, since then, that shows that the court, or general court again, I mean, is using its full jurisdiction to actually apply, I mean, this level of scrutiny that it has to apply, meaning that we review any type of elements as the court asks us to do, and we take that into consideration. I mean, for the sanction, I mean, this we can substitute our own assessment. That point is, I guess, I mean, the limit that we have to do in the legality control. So in terms of legality control, we have kind of an administrative review, so meaning that we cannot substitute our own assessment to the commissions, and we do have to, or we have to basically review only whether or not, I mean, the process was legal and the type of elements, I mean, that the commission relied on, I mean, were sufficient. But if there is an option there, I mean, we are not supposed to say that, I mean, a better option was available to the European Commission. So when we had this period where criticism were actually voiced against, I mean, the judgment and I remember, I mean, the deference that was mentioned towards the Commission from the court, and we may have actually written against this deference or the existence of that deference, because inside here and in the building of the court, I mean, I can tell you there is no deference whatsoever, and we actually review all the elements. The last 10 years showed, I believe, I mean, this a more in-depth review that was supposed to be done before, but not because, I mean, we are doing our job differently, just because, and this is a topic I guess, I mean, we'll discuss a bit later on. This is just because I mean, competition law is more sophisticated today and relies more on economic evidence. So we left a little bit, I mean, the object box. And whenever you have the economic evidence, I mean, you have this risk of giving more room to discretion of an administrative body, because normally our review should be a little bit more limited, let's say. That's basically what the court said, I mean, a long time ago. However, once again, limited is just because we should not substitute our own assessment. That doesn't mean that we do not have to review all elements in facts or in law that have been used, I mean, in the Commission decision to actually justify, I mean, the decision. And this is what we've done. I mean, in all cases I've seen, I mean, since the 14 years, I mean, I've been at the court. I mean, we are really, I mean, reviewing all these elements, and we are reviewing them in depth. Um, even if there are economic evidence, scientific evidence, or technical evidence. I mean, this is basically what we do. Um, I mean, for this, we have different ways, I mean, to review something that we're not specialists of. But I mean, this, I guess, we'll come to that as well a bit later on. But once again, this is basically the last 10 years. I believe that we have really showed, I mean, to the legal world that, I mean, the general court is actually doing its work, I mean, quite in depth. When we think we should not go, I mean, I mean, deeper, it's just because we believe that there is no need to do that. And then the court might tell us, I mean, otherwise, as I mean, the court did, I mean, in Intel, for instance. But then, I mean, we review our decision, and this is the normal process between a first instance court and a court that judges our judgment under appeal. So.
Thank you very much. I have a follow-up question, but let me move it to Maria, and then maybe I'll ask all three of you.
I agree with what Vivien said. Basically, it is there is this standard, long-standing standard of unlimited jurisdiction, and of course, there have been some cases where the exact scope of the judicial review has been criticized, but overall, I think that what has generally been applied so far is in line with the general principles on unlimited jurisdiction.
And George?
Yes. Well, I would simply say that one should always bear in mind that our system is a purely administrative system, whereby the Commission adopts a decision in competition law matters, whether that is Article 101, 102, or mergers. And then it is for the parties that have standing and the legal interest in seeing that decision annulled that must it is for those parties to bring an action and to raise pleas in law and fact in order to see that decision annulled by the court, the general court. So it is for them to choose and then raise the arguments they want to raise. Now, that is why I believe that when one asks the question, how far would the general court go in reviewing the legality of a decision, then one must always bear in mind that the court is constrained by the arguments that are raised. That is one thing. Second thing is that it is for the Commission to prove either an infringement or indeed the fact that a merger should be blocked and therefore cannot move forward. So the court must see in the contested decision a full statement of reasons that support the operative part thereof. Once the court is satisfied that this is the case, then the court will have to examine all the pleas raised, and of course the sufficiency of the reasons may also be raised, but may also be examined of the court's own motion. Now, when the court starts dealing with the very substance of the case, then again, the court cannot go further than what the parties ask the court to do. So, with regard to economic evidence, it is for the parties to bring that forward and to invoke it before the court. I don't think, my dear friend Vivien said, I don't think that to the extent a party brings forward some evidence that is relevant and is liable to overturn the conclusion at which the Commission arrived in the operative part of the contested act, that the court will simply not see it or not examine it. Quite to the contrary. That is for sure, provided, of course, that that evidence is relevant. So I don't think we should analyze the court's, let's say, approach in a vacuum. It is we should always bear in mind that it always depends on what is raised before the court. And every time something relevant is raised that is liable to question the result of the case, then the court always examines it and draws the conclusion it sees fit in law and fact.
And this links me perfectly to the follow-up question which I wanted to ask. So basically, we can identify, at least in the UK discussion, two camps. Some saying that it is really important, quintessential, what standard of judicial scrutiny will be allocated for the new act, and others more pragmatically say, well, it's just, we're changing vocabulary, but if the stakes are high, you can problematize even, or thematize, let's say, even the lighter standard of review, and you can find law is a living organism, and you, by having skillful lawyer interpreting different provisions, you can look and lead to significant implication even with relatively light or in textbook style taxonomy, lighter level of scrutiny. Is it the case that the court always has an opportunity to say everything pretty much which it wants to say? We know that you are limited, the court is limited to what you are being asked to say. And you know that, for example, if you look at the preliminary reference procedure, you are only bound to interpret the provisions of EU law. But somehow we know also that the scope for maneuver is there. Is there an appetite? My follow-up question is there an appetite in more competence, or you are quite satisfied, or the court is quite satisfied with what it has? Let us start again with you, Vivien, and then Maria, and then you, George.
And I was I was waiting to see if George would jump on that question, because it really depends on which court you're talking about. If you talk about, I mean, the general court where I work, or if you talk about the Court of Justice where George works now, and George used to be my colleague, I mean, at the general court, so he knows exactly, I mean, how the general court works. But I'm not sure. I mean, we have the same margin of action, I would say. So to answer your question, first, I mean, under an article, I mean, 263 of the treaty, so meaning the an annulment, an application for annulment. I mean, can we do whatever we want because we can always turn the thing? The answer is no. Honestly, is no. Maybe George, I mean, would not share my opinion, but I mean, in terms of practice, I can tell you that no, we cannot, for two reasons. First, I mean, because as George underlined, I mean, before, I mean, the arguments that are put in front of us, I mean, they are the one, I mean, that we can use, you know, I mean, we cannot use, I mean, arguments that are not in front of us. So that's one thing. And believe me, it happens, and sometimes, you know, I mean, I guess, I mean, some of us, I mean, have, like me, an experience as a qualified lawyer in law firms, and some of us, I mean, sometimes, I mean, when we read, I mean, the application, we're like, I mean, why this argument has not been made, you know? So, but the argument has not been made, and we are not the one that should make the argument. So we're limited by that. We are limited by the standard of review. Even if people think that with a lighter review, we can do whatever we want, or we can go more in depth. At the end of the day, and this is what I was saying about, I mean, the difference between the General Court and the Court of Justice is that if we go too far, the court will tell us, right? So yes, of course, I mean, we can push, of course. I mean, this is somehow, I mean, the role of the General Court, I mean, as a first instance court, sometimes, I mean, we are the first, I mean, getting the new cases, right? So we are setting, I mean, the first limit, but the Court of Justice will tell us if we were right or not. And then if we were not right because we went too far, I mean, remember Alrosa, for instance, where we substituted our own assessment. That's what the court said. That's what the court said. But sometimes, I mean, we are not going as far enough. And that's the MasterCard case or the Carte Bancaire case, I mean, where they said, yeah, I mean, you should review actually the effects, you know? So basically, no, we cannot do whatever we want. That's not true. Well, actually, I mean, in practice, that's not true. And believe me, each time I try to, I mean, just push a little bit. I mean, my judge will tell me, you're not the one who should do the argument. So the argument is there. I mean, we are supposed, I mean, to judge this with this standard of review. And we are doing it, I mean, in competition law as we do it in other fields. I mean, with the limits of the standard of review. This is why, I mean, at the beginning, I talked about, I mean, the unlimited jurisdiction or the full jurisdiction we do have, because when we do have this, yes, we can go further. Under the legality control, we are constrained by some limits. And no, we are not, I mean, rewriting, I mean, the pleadings. We are not doing that. If we do that, I mean, then you'll move to George, and George will tell us on appeal that we went too far, you know? So that's basically, I mean, why I said, it depends which court you're talking about. The preliminary ruling procedure is something different. I will leave my colleague, I mean, talk about that because, I mean, maybe in a year or so, I mean, you can ask me this question because we're going to get, I mean, preliminary ruling procedure as well. I mean, with the reform, we'll discuss that, I guess, I mean, a bit later on. But for the moment, I mean, that's for the court. And you have here, I mean, a former colleague from an advocate general and a colleague at the court. So they can tell you, I mean, how far they can go, even if they are constrained by the question, but they reformulate this question sometimes. That's for them to answer, I guess.
Thank you very much, Vivien. Maria, that was a very elegant pass from Vivien to you. How do you see it from the perspective of Advocate General as well, but maybe also from other corners of the European of the Court of Justice of the European Union?
Yes, I think what Vivien said, that there needs to be a distinction made between the General Court and the court, is true, but we need to make also another distinction between the judges at the court and the Advocates General. Now, Advocates General are actually also members of the Court of Justice, but they have a somewhat different role. Their functioning relates to a previous institution called Rapporteur Public in some national jurisdictions. And their role is actually not only to solve a case or to prepare a file for the court to decide, but also to test new ideas, sometimes to delve deeper into arguments. So in a sense, it is a very tricky question because obviously the Advocate General cannot replace the parties' arguments. They cannot, in any case, change the subject matter of the case. But what, especially in preliminary rulings, is possible is that the Advocate General has, in a sense, provides an overview from a more general angle, from a wider perspective, and looks into the different pieces of the puzzle. For example, what would be the implications of a specific question on other matters of law, and it kind of prepares a wider analysis of a case than would the strictly formal procedural rules for the court allow. Maybe George can elaborate more on that as well.
Right. Well, I'm in total agreement with both my colleagues, and I'm afraid there's not much left to say. Maybe I could sum it up by saying, first of all, we should always remember that there is no one size fits all in those concerning those questions. To be more precise, with regard to judicial review, there is no one size fits all in the sense that the type of review that is exercised by the General Court and possibly on appeal by the court if the case arises depends on the legal framework we're supposed to apply, meaning that there are provisions that may grant discretion to the author of the contested act, and there are provisions that do not grant discretion to the author of the act. And if we understand that discretion, as Vivien said a few minutes ago, is the existence of an option, and it is always by reference to the applicable provision that we will assess whether there is an option for the administration there, this shapes judicial review. If there is no option, then this will be or will also be reflected in judicial review, in the sense that where there is an option, let's say options A, B, or C that were open, and the administration followed option or adopted option A, it is not for the General Court or indeed for the Court of Justice on appeal to say, no, we would have preferred option B, although it is equally legal and equally valid to option A. And of course you can also understand what the situation is when there is no option. If the law leaves only one option to the administration, then the administration has to follow that option, or else it may be subject to raising the correct plea by the applicant. It may be sanctioned by the Court of Justice, by the General Court and or the Court of Justice. With regard to preliminary rulings, if I understand correctly the real issue here, one should always bear in mind that the national court, when they make a reference for a preliminary ruling, they have to explain the case pending before the national court. And it is for them to explain to the Court of Justice why they need an answer to the question they're asking in order to solve their case. So when the court sees what the case before the national judge is about, then the court can understand why they need to answer the question and possibly whether there are other provisions of EU law on which the court has not been asked that might help the national judge solve the case pending before them. So in that sense, yes, there is some margin. But of course, it's not like the court can do whatever they want. The court should always explain why an additional provision is relevant and will help the judge to solve their case. And that's how it should be interpreted.
And obviously there is scholarship by legal historians who basically say, tracking back to the origins of the preliminary ruling mechanism, saying that most of the preliminary ruling requests have been drafted by lawyers. Does the court have to be mindful of it, or is it something which goes beyond even the very mechanics of consideration? Do you have to be aware of the broader socioeconomic political context? Do you have to be, I know you cannot answer hypothetical questions, but do you have to somehow to do this kind of assessment how real the question is, even if formalistically speaking it is real question?
I think, first of all, I would expect that it is a very common practice for lawyers that appear before national judges to propose questions for a preliminary ruling if they so wish. And then it is always for the judge to decide whether it is expedient or necessary to ask those questions. That is one thing. However, a different issue is whether the question as asked is really relevant in order to resolve the case pending before the national judge, and that should be the case. Now, we all know that there is, of course, the court places, let's say, the burden on the national judge, but also considers that there is a presumption that every question that is referred to the court is relevant. So because it is the responsibility of the national judge to make that determination, meaning whether they need an answer to that question. And it is only if it is clear that the question is not relevant that the court will decline to answer. But maybe Maria would have something to add on that.
I completely agree. I think that in terms of, again, the work as an advocate general, we are equally bound by the exact word, by the exact question of the national court. Now, there is also some discretion in terms of formulating the question. And as you know, many preliminary rulings come from many different member states. So there is also a linguistic issue. Basically, all the preliminary reference questions are translated into French so that everyone can work on a specific basis, but still there are some nuances that cannot really be always depicted exactly as they stand in national law. So it is, to a certain degree, also possible to try to understand the context. It is necessary to understand the context of the exact preliminary question, but overall, there is limited possibility to really go beyond what has been asked, and it is for the court only to reply to what has been asked.
Thank you very much, Maria. Vivien, in answering this question, I also wanted, please answer the question, because if there is such an enthusiasm, I'll ask it as a separate question.
No. Just, I mean, I cannot really answer the question. I told you, I mean, maybe in a year or two, I mean, I will when we're going to deal with a preliminary ruling request. But no, I mean, my question was more about, I mean, your question. What is exactly, I mean, the problem here? Are you underlying the fact that basically some questions come from artificial cases, that they are actually not real cases? They are just, I mean, built, I mean, to get an answer from the court. I mean, if this is the question, I mean, and I'm not talking about the formal rules. I mean, we all know the formal rule that, I mean, we cannot answer hypothetical questions or something like that. Okay, fine. The thing is, I mean, it's not very surprising that sometimes, I mean, the court will answer a question that is actually expected, because what happens, I mean, is basically, look at, I mean, I'll give you an example. Look at damages. In damages, I mean, we had questions about, I mean, how far, I mean, we can ask a parent company, I mean, to be responsible for the subsidiary, and the other way around. Okay, all these type of questions happens all the time, you know, at national level. They happen all the time. The thing is, I mean, we have one case one day that is linked to this question, and then we may answer, the Court of Justice, I mean, may answer to that question in a way that is not that clear, you know. And whenever you go to conferences, I mean, you will have this this little wording from people criticizing, saying, yeah, that's not clear. Maybe we should have another judgment that will give clarification. But actually, this judgment will come. And it's not because, I mean, the case is not real. It's just because, I mean, this is a question that was basically triggered by a judgment that we may have had before, may also have been raised by an advocate general's opinion that actually have seen something here that is an articulation that we cannot actually answer in judgment, where and that is linked to the opinion, but will be I mean, actually raised in another case a bit later on. So the thing is, I mean, it's not because, I mean, we have these questions in the air, and that we do answer them in a judgment that actually, I mean, we use the case to answer, or the other way around. It's not because we have this question in the air that actually a national case has been built, I mean, just to answer this. It's just because, I mean, these are the question that we do have to answer slowly, you know, in building the case law, I mean, towards one specific legal issues, you know. So that's basically, I mean, a criticism that I hear sometimes, and I don't think, I mean, it's actually really, it doesn't really fit the reality. So that's basically, I mean, what I wanted to say. But as I said, I mean, maybe I will know more in 2 years.
Absolutely. I think this you know, it helps us as outsiders to understand better the mechanics of decision making and law making or interpreting, so that it's the motivation is purely, you know, epistemic. It's not normative judgment or any, you know, any of this kind. I'm glad you take it from this perspective as well. So maybe we can also
remember, I mean, the point of the court is to clarify a legal situation. So it's not, I mean, to blur situation, you know. So that's the point. So maybe sometimes, I mean, we're not clear enough, but okay, I mean, we'll have other occasion, I mean, to bring some clarification. So that's the point.
Let us now have a look at you mentioned in passing, all of you, that we are now in the midst of institutional reforms and not necessarily formal architectural revision, but rather we witness significant changes in terms of the cases, how many competition cases come to the court, and how much time is being dedicated to each of it in proportion. You mentioned recently, Vivien, in one of the conferences in Warsaw, that when during the legislative process we do different impact assessments, but we seldom somehow pause as co-legislators and think about implications for the judiciary in terms of what would be the outcomes from judicial perspective. Obviously, we have DMA, and we have few questions on the DMA to discuss earlier today, but maybe you can remind us or outline to us the main changes which we will have very soon in the EU judiciary system.
There are a couple of things, I mean, listen, that you mentioned that I could address, but I mean, you'll tell me. I mean, if you want me to come back to the impact assessment, which is one of the problem we may have, but I will try to address that in my answer. Okay, the thing is, we've seen an evolution in the judicial architecture. I mean, in the past, again, 10 years somehow, with the doubling of number of judges at the General Court. So now we have 2 members or 2 judges per member state, and so we have more resources normally, I mean, to deal with an increased level of cases. The thing is, of course, I mean, if we produce more, I mean, you will have automatically, I mean, more appeal, and then, I mean, the court will be swamped by these appeals. You know, the European Union has more and more competences, so it gives also the possibility to have more preliminary ruling requests, and then that goes to the court. So the court, I mean, is quite swamped. So the point is to use, I mean, the reform that was done, I mean, or finished, I mean, normally in 2019, so the doubling of number of judges at the General Court, to transfer competences. And the Court of Justice of the European Union has proposed, I mean, this transfer of certain fields, I mean, in preliminary ruling procedure, I mean, to give competence to the General Court. Okay, this is a possibility that we had already in 2001, I mean, 2003, I mean, for the entry into force of the Treaty of Nice. That was never done actually, because the court had to tell, I mean, basically, or propose the transfer in some specific fields. This is done now, and a couple of days ago, actually the 7th of December, the co-legislators, so the Parliament and the Council, reached an agreement, I mean, to transfer the competence of preliminary ruling in several fields. I mean, namely the excise duty, the custom code, the tariff nomenclature, and the right of passengers, and finally the scheme for greenhouse gas emission allowance trading. So that's basically what is transferred. If the court actually decides, I mean, to transfer the case or the question, because the court can always keep it for itself. So we will have more possibility, I mean, to use our members, so the number of judges we have, I mean, to deal with preliminary ruling procedure. Why is it important now? I guess, I mean, it's because, yes, we have seen a drop in competition law cases, a huge drop. I mean, just, I mean, to give you some figures, I mean, in 2010, we had something like 80 cases, new cases, that was introduced before the General Court in competition law. So I'm not talking about state aids, but I mean competition law cases, 80. In 2016, we had 18 cases. Last year, we had 8 cases. So, and basically this year, I mean, we're almost at the end of the year. We have, for the moment, in something a bit similar, like 8 cases, new cases that was introduced. So we should have more time, I mean, to deal with these cases. But there is a nuance here, because even if we have less competition cases, the cases we do have are very complex. And just to give you a very easy way to realize that, I mean, we never got so many 1 or 2 cases. And these 1 or 2 cases has been or relied on economic analysis, which is, you know, more complex. It takes time. They are huge cases, very important cases with very important sanctions. And it takes time then to review all, I mean, the documents that are actually brought to our review. So it takes time. And the problem is, in this field, we do not have time, because the problem is we need to give an answer that is a useful answer. I mean, look at the problem we do have in Intel. I mean, the case, I think, I mean, dates back 2004. It was introduced before the General Court the first time in 2009. And it's still now at the Court of Justice under a second appeal. I mean, this is a long time. Okay, so if you consider the possibility of appeal, I mean, and the review at the General Court, I mean, all this takes takes time. I'm not sure that's a reason why we have less cases. What I know is that it takes time to review these cases and to do our job well, and we have to do it, I mean, as fast as possible. So basically, I mean, we're going to have more competence, that's for sure, but we are using our resources, I mean, to actually try also to reduce the duration of proceedings, especially in competition cases. This has been done, I mean, with sometimes with success, sometimes not, to be fair. But we are still, I mean, focusing on this. And the problem is, and we'll finish with that, the problem is when the legislator gives or adopts a new legislation, and that is the case for DMA or DSA, it can create, you know, more and more cases. And that's the thing is never seen. I mean, how, I mean, what is the impact on the judicial architecture or the judicial or the duration of proceedings, for instance? We've seen that with the banking union, for instance. After the crisis, the financial crisis, I mean, a huge piece of legislation was created, I mean, for the banking union. Okay, that created, I mean, a huge litigation before the General Court. And right now, I mean, we have many cases that are linked to this piece of legislation, which is also complex and it takes time. So the reform of the judicial architecture and the fact that we have more members, I mean, have been used, I mean, to try, I mean, to fix this issue or to answer this challenge that is created by the legislator without thinking of the consequences on the judicial architecture. For DMA and DSA, we don't know. We don't know. Sometimes, you know, we do not have, I mean, this flow of cases. We thought that with the REACH regulation in this chemical substance, and we would have many cases. We actually didn't have so many, but they are also very complex. So it takes time as well and takes resources. DMA and DSA, I mean, they are also, I mean, for some aspects, I mean, quite complex. We will see that. How many cases we're going to have? We don't know. We just received this first, I mean, DMA and the first DSA cases that we allocated now. And we'll see, I mean, how much time it takes. But once again, this is something that is not taken into consideration and may have actually a huge impact on how the court is seen to answer, I mean, the challenges that is raised by this new piece of legislation.
Thank you very much, Vivien. Maria?
Yes, to pick up from where Vivien mentioned the duration of proceedings and the long, complex analysis involved. I mean, Intel is certainly a special case with the double referral, but we can see also in cases like Google Shopping that we have had a duration of over 10 years for having a decision that is final. And I think there is a white elephant in the room that is the huge resourceful economic analysis that needs to be undertaken by enforcers. That is due, obviously, to the long-standing, more economic approach that was developed originally in the US and that has been adopted by the EU as something back in the day which was considered modern. And now the results from that are also having lengthy procedures because also in the in some decisions we see that the Commission takes a lot of resources and pages to just carry out certain economic tests, which sometimes complicate things than really make enforcement more effective. So I think that in a sense, we're seeing also a shift in the perspective of approaching competition law in general, maybe also other areas of law, but with competition law, it's very obvious that the Commission is rethinking its approach. We're expecting new guidelines next year on the enforcement approach regarding Article 102, and the DMA could also be considered to some extent a counter model to this extensive economic heavy analysis. But we'll have to see what this means for the litigation at courts level.
Many thanks indeed, Maria. George?
Yes, I would just pick up a little bit on what Maria said concerning a possible shift to other types, more regulatory types, and through the adoption of instruments of general application with regards to antitrust enforcement. I would say that if there is a finding, as it was the case with the DMA, that the traditional antitrust approach is not 100% fit for purpose for reasons relating to the markets involved. And second, there is a solid experience allowing to presume anti-competitive effects stemming from specific practices. Then it can be, yes, a regulatory approach whereby the Commission proposes the adoption of an instrument, a legislative instrument, that imposes obligations which are supported by solid experience in terms of anti-competitive effects, then that can be a way forward. And that is what the DMA is more or less about, so far as the obligations it imposes are concerned. Of course, there might be some disagreement as to the details of every single obligation and whether they are really grounded on solid experience or not. But that is something that may or may not be raised before the general court when the time comes.
Thank you very much. I wanted, being mindful of time, I wanted maybe to merge some questions and rephrase them. I know, Maria, you were quite explicit by stressing the specificity of the more economic approach, and that we are with DMA and maybe with other instruments, we are shifting from this syllogistic kind of discovery of the economic truth to something which is kind of more policy oriented, requiring greater regulatory discretion. Is it a trend which we will be invoking in the DMA? Should we somehow and maybe looking also at this neo-economic formalism, which some authors try to use this vocabulary, so it replaces the good old legal formalism with the dictate of economics, neoclassical economics? Is it something which we somehow can thematize and observe as a new trend?
I think that the DMA introduces indeed a paradigm shift in the sense that it introduces a completely new system of enforcement. However, it is not completely far from competition law. As we see also in the DMA itself, there is an explicit provision that it is complementary to competition law. It has specific own goals, but it's not foreign to competition law. And in terms of the potential spillover effects of competition law to the DMA, I mean, we have already seen certain cases that were on the verge of different areas of law. For example, data protection law when it comes to data processing activities by big players, think of Meta, which has in the past been very cautiously touched on by national regulators. The Bundeskartellamt was heavily criticized in the past for going towards such behavior and addressing it with the means of competition law. But we see now that actually the very same conduct that was subject to the Meta case is also part of the DMA in Article 5. And we have also seen that the Court of Justice is also open in general to consider the implications or the interrelations between the different legal frameworks, that in certain instances also the violation of data protection laws can be a vital clue to infringement, to certain infringements of competition law. So I think there would be a multifaceted system. I'm not sure if formalism or departure from formalism is the right way to name it. In any event, there would be interrelation between the different legal frameworks. And what we should in any event avoid is legal certainty in terms of the applicable legal standards. And it should always be clear when there are different regulators, who is the one to regulate, and how cooperation between the different regulatory bodies should work. So I think the principle of sincere cooperation here can be a leading help.
Thank you very much. Vivien, how do you see this situation?
Sorry, I mean, my mic was on mute. Sorry, on which point do you want me to react?
we believe that there is an economic there is economic truth. It's complex, but we have complex toolkit. It is even more complex, but we bring econometrics, and there must be the right answer. With the DMA, supposedly, it's more about choices rather than economic truth par excellence. Is it something which have to be taken into account, or it's more kind of academic construct than real reality?
All right. I mean, I think that's something we discussed in another conference. And my answer is always the same for the moment. At this stage, what do I see? I see that the General Court pushed towards a more economic approach. That has been discussed before. The court pushed for that. That was at the beginning of the in 2000. That when the court asked, for a more sophisticated rezoning in competition law. So the General Court pushed for that. We've seen, this more economic approach. That was also in the US and came here and moved towards, the Court of Justice, giving us, some directions on how deep, we should look at the effect analysis. So we did that. We did that in 101 and we did that in 102. We tried, to find a way to assess, this economic evidence. And I think even if, there've been quite, some criticism on that, we have been doing that, and we are doing that, actually in quite proportionate manner. Now, you have an answer from the legislator to fix an issue, which is also a question of time, because it takes time and uncertainty. Actually, that's a question that I have asked myself. Do you think, really think that, our judgment, because they rely on this review of economic approach, will provide, uncertainty, legal uncertainty? I don't believe so, actually, because we've always been back to principles, principle that hasn't moved, because, we know, the theory, the economic theory that is behind, competition law. So we're always back to this. Then, we appreciate it. We have done sometimes a different appreciation that the court, required us to do. But actually, I don't believe that there is a legal uncertainty, but more, an approach that is actually pretty much the same, which is trying, to give proportion, to all the margin of discretion that the administration should have, and also, the freedom that an economic actor, whether or not dominant or whether or not, active with other competitors on the same market, should have to determine its own behavior. Okay, fine. Now you have seen the in this specific market, in digital market, you've seen issues that need answers. All right. So the legislator, adopted a legislation, which is actually something that we really know. At the General Court or the court or the judges, they know how to review this kind of approach. And actually, Maria talked about sincere cooperation. I will talk about the principle of proportionality, because it's always the same. You've seen a discussion about the heavy obligation that you have on gatekeepers, for instance. Yeah, okay. We will review that, and with the same principle that we do have, and we have always applied. When we have a regulator providing a new framework, and we have this, at the end of the day, this assessment of the proportionality there. So somehow, at this stage, as I said, at this stage, I don't think, we're trying to find the truth into economics, or now, we are trying, to answer, a problem at the court, as I said, a problem on a fast-moving market that we couldn't find before. So I'm not sure it's a trend. I'm sure, it's an attempt, to answer issues that were actually not overlooked by the judge. But as I already mentioned, the problem is probably, the duration of proceedings. And if you need a fast answer, then And this kind of certainty, but once again, I don't think it's a legal certainty that we were not providing. If you want a fast answer, okay, maybe, I mean, the legislator has to do something. But you know what? And I will finish with that. You know what? I mean, this is also something that, I mean, is not new at all. Because when the judge, I mean, sees something that the judge cannot answer, he will actually call for a legislative action. We've seen that in other areas, and the legislator, I mean, will take its responsibility, I mean, to adopt a piece of legislation. So, I mean, this movement is actually a movement that I've seen before, and that we will handle, I mean, with the same kind of legal tools that we've been using, I mean, for years now, I mean, to try to answer, I mean, a challenge that is on the market that has, of course, its specificities, but that is not something really new for a judge. That I should stop here, I guess.
Thank you very much, Vivien. George, and maybe if you can also combine it with your amazing paper, where you examine the DMA and which aspects of the DMA will be most plausible to be kind of challenged in the court.
Let me just start by saying that there is an extensive background to the DMA, both historical and economic, in the sense that the DMA is born out of antitrust experience of many of various forms, in the sense that we have former cases that have informed the DMA, we have market studies that have informed the DMA, we have stakeholders that have given information and feedback to the Commission in order for the latter to elaborate its proposal to the co-legislators. And since that proposal was made, we have tons of studies that have been conducted addressing each and every obligation and analyzing the context, the background, and how markets work in each and every one, in order to raise issues or in order to explain why something is this way and not that way, why it should function, what are the consequences depending on the policy choices of gatekeepers. Now, therefore, it is not like, as I understand it, at least, it is not like the legislators or the Commission woke up one day and said, "Well, let's establish some rules so that we don't really have to deal with Article 102 anymore in those markets. We don't have to apply Article 102 and its lengthy and heavy procedures in those markets." So that is one thing, and then in the impact assessment, we can see in the impact assessment report, we can see a summary of the considerations that underlie each and every obligation, not each and every, but because, let's say, some of them were added within the process by Council and the Parliament. So that is one thing. Then I suspect that what we will have now, leaving on one side the actions for annulment that have been brought against designation decisions or decisions to open market investigations, what we will have now is actions for annulment within the framework of either non-compliance or within the framework of a possible refusal by the Commission to further specify obligations under Article 6 or 7, or actions for annulment of decisions, of implementing decisions adopted by the Commission that do further specify one or more of those obligations, right? And I consider that it is within this framework that we will see, as the case may be, a new corpus of judgments that will arise, and applying all those principles Vivien referred to before. And within this framework, we may see, again, depending on the grounds for annulment that will be raised, we will see how the General Court will approach the legality of the DMA itself, if there are any pleas to that effect, the analysis undertaken by the Commission in order to further specify an obligation or to abstain from doing so, and in order to find non-compliance.
Thank you very much. And do you think this first DSA case, or one of the first cases where Amazon starts referring to this kind of first order principles like equal treatment, is it something which is very plausible to be escalated or scaled up to the whole geometry of the DMA, where there are some unequal by default, so to say? Is it something which is potentially is it possible to be thematized, or it's rather
Is the question addressed to me? Okay, look, I will give a very short answer to that, and then I will leave it to Vivien, because all this is now before the General Court. First of all, it is not the first time that one asks oneself about equality of treatment in a context where the legislator has taken action only with regards to a specific set of actors, operators. We've seen that, for example, in the system for greenhouse gas emissions, where certain industries were regulated before other industries, and the court made an analysis of that in Arcelor, if I'm not mistaken, in early 2010, again, if I'm not mistaken. So that is one thing. The second is that the particulars, or if you like, as always, the devil will be in the details, and it will always be, yeah, as I imagine, about the degree of the intervention. So we have to bear in mind that there is a different standard when the court reviews legislative action and the adoption of legislative acts of general application, and a completely different standard when the court reviews individual acts that impose obligations, right? So, so it is by reference to a different set of criteria that the court will review the legality of the DMA as such, and it is a wholly different set that will a wholly different background that will apply when the court will review the legality of individual acts finding non-compliance, or indeed specifying an obligation that has to and the specification has to take into account, as the DMA provides for, of the specific circumstances of the gatekeeper and the core platform service.
Thank you very much, George. Maria and Vivien, do you want to add to this aspect?
Maybe one could just add that yes, indeed, there is some inequality by default, in terms that the only gatekeepers that for few specific criteria are targeted by this regulation. And yes, there is no efficiency defense in the same way as there is maybe in other industries in terms of traditional competition law. But I think that I agree with George that it depends a lot on the exact argument, and just by the fact that these companies who are gatekeepers are targeted, this in itself does not suffice to consider the system illegal or not proportionate enough.
Many thanks.
Can I pick up on something, because Maria mentioned something very interesting about the absence of the impossibility to raise efficiencies or other objective justifications as arguments to counter non-compliance. As I said before, this appears reasonable, as it is part of the design of the DMA, in the sense that if each obligation is a distilled form of an analysis, a greater analysis that has been undertaken as to the effects of the specific behavior in the specific market based on former cases or on other types of information and data that were at the disposal of the Commission and the legislators, and they have concluded that there can be no efficiency borne out of that conduct, then it is only natural that when the DMA is adopted, it does not allow any such argument to be made. Conversely, when you have a general clause like the one under Article 102, which is just one article which describes in general terms what is forbidden, then it is only natural that you can allow for objective justification or for efficiencies and other objective justifications, simply because it will all depend on, it is all fact intensive. It will depend on the market, it will depend on the actors, it will depend on the specific circumstances of the case. But the DMA, again, it is what the legislators deem that we know from past experience, either practical or academic or otherwise, in a distilled form.
As an act, but each circumstances, as you said earlier, Vivien.
And I should have reacted immediately after what George said about objective justification or efficiency defenses under 102, because as we all know, that is an argument that is really welcome with the court and in the case law. No, I mean I will exercise my right to remain silent for this question, because it is before, I mean, the general court, and right now, I mean, that is discussion that we do have here. The only thing I would say is that, I mean, I was really, attentive to what my colleague from the court said, because, I mean, this is important for the general court. But the thing is, I mean, it's true. I mean, we have here, I mean, a difference between, I mean, this general act and what is done, I mean, after that, with the principle of equal treatment. The thing is, it's always the same with this principle. I mean, it applies only to, I mean, a similar situation. So that's the point, that all the discussion we're going to have, I mean, are we in a similar situation here? And what are the arguments brought forward, I mean, to be in a similar situation or not? And this is exactly, I mean, what we're going to review. And believe me, we're going to review that, I mean, in depth. And this is basically, I mean, how, I mean, this argument will be answered. So that's the only thing I will I will say for the moment. I will be happy to comment whenever we adopt a judgment.
Okay, you can use you can exercise your right to remain silent only once, but the next question you cannot. And this is a question which concerns me for quite a while. I remember me asking it. One of my colleagues, mature, experienced professor Alan Patterson from Strathclyde, and all his life he explores how judges think, what parties want, and all these kind of legal sociological questions. And I was like very naively asking him, what do they read? Do they read constantly Dworkin and all these kind of big philosophers 24/7? Do they are always preoccupied with this question? Let me start asking again with you, Vivien. What is your observation? How important these subjective elements are? Do judges continuously in this kind of deliberation mode, or is it something which is very, they are normal mortal and they walk on two feet, and thus subjective elements are there?
You have as many answers as we have members of the court. They're all different. They're all different. But actually, I mean, it's true that a few of them will read, I mean, actually different sources that you would not even think about. And this is quite interesting sometimes when you see this discussion, that our process is written. So basically we have memos and notes and stuff like that. And it's quite interesting, I mean, to read some of them, because you always learn. I mean, as a legal secretary, I mean, I always learn from judges that takes time, to put everything into perspective. That is actually goes from the Roman Empire, I mean, to something that is, I mean, actually discussed in sci-fi literature. So I've seen many things in 14 years, at the General Court, many sources. But it really depends on the judges, really. And this is why, it's quite interesting, I mean, to have these judges coming from different backgrounds. It's not a career judge. They come from different backgrounds, and they bring with them, I mean, their own experience and their own interests. So they do read, yes, a philosopher. They do read as well the doctrine. I mean, this is something that we do read as well. That's another question that you may ask yourself. I mean, to what extent, I mean, they read what we read, because we, as I said, we are little helpers, and we also read things and we bring, to their attention or something else. So it's this mix of, this exchange, and that's the beauty of that work. This exchange between a judge and his legal secretary, first between the judges in themselves, and that will change, when you have someone that comes from a background from Scandinavia, another person from, I mean, a Mediterranean Sea, that also can have an influence sometimes. But as I said, if you look at the background of all these judges, some of them have economic background, others have literature background. This is something that you never really you can really anticipate. You cannot really anticipate what you're going to have. Every 3 years we change chambers. Every 3 years, I mean, I discover something, because I will work with another judge, I mean, as an assessor, and then I will have sources coming from, I mean, something that I could have thought irrelevant, but actually, I mean, it will give me a new perspective on something that I thought I knew. So that basically, I mean, a long answer for a very, actually, a short answer that should be is, it's a mix of everything.
Maria, please provide us a longer answer as well.
Maybe just to add to the bit of everything, in any event, judges at the court must read one specific thing, that is the opinion of the Advocate General. I think this is the clearest piece that is out there to be read. But in
We
terms
read them.
of...
We read them.
It is very very specific to each judge and also to each Advocate General, but especially given the role of Advocate Generals standing out there with their name eventually. We don't have a system like in some other jurisdictions with dissenting opinions. It is always the court that decides something. So Advocates Generals are a bit of an exception there. And it is all the more important that what they draft is really also in alignment with what they consider to be right. And therefore, of course, knowing the doctrine is and being in generally familiar with the case law is extremely important. Maybe just to add one tiny anecdote, there is a famous article by former Advocate General Bobek, who wrote on the role of the Advocates Generals at the court. And he said that basically AGs are the fourth in the court. Actually, they're not really supposed to be there, but they have a special function. And I think this shows again that the Advocate General has a more, to some extent, a higher responsibility towards the general public to present a matter from different angles. And of course, in the end, if the court follows the approach or not, it's an entirely different question. There is also not always an opinion, maybe only in the half of the cases, but it is an important piece of the functioning of the court.
And thanks indeed, Maria. George.
I am not sure I have something to add. I agree with practically everything that was said in that respect. So yes, I will stay with that.
Okay, let me then ask you the final question. We have quite a long list of issues which we have not covered, and among others, there were some which have been mentioned. How can a gatekeeper promote competition? How can it be guaranteed that the current antitrust and regulatory law does not sanction market dominance as such? One of the questions, maybe you can pick one which resonates most. Is the Commission under the duty to respond to each instance of non-compliance? Is it something kind of syllogistic, or we assume discretion? Is it okay to delineate so narrowly the scope of core platform services? UK went with digital activity, you know, and the digital activity is anything which is done predominantly digitally. Do you want to pick anything from this list? We have more questions which we didn't address.
Right. Well, I could say, how can a gatekeeper promote competition? First of all, I would say that the DMA is supposed to promote competition, to keep markets fair and contestable, and that is what it is meant to do. So, if a gatekeeper considers or shares that view, then one option is to comply with the DMA. That's the obvious thing to do in order to promote competition. And of course, we have to bear in mind that fairness and contestability are also well-established notions within competition law, within the traditional competition law. You also ask, how can it be guaranteed that the current antitrust and regulatory law does not sanction market dominance as such? I would say that, first of all, the criteria under the DMA are different. They are not about market dominance. You have specific quantitative and qualitative criteria that do not necessarily amount to market dominance. And then what the DMA sanctions rather is, it's clearly not market dominance as such, but it does sanction, or it does impose obligations that preclude specific behaviors. They do not preclude market dominance as such. Now, you asked about did you ask about the influence of the DMA on the case law of European courts concerning competition? I see there might be some crossing points there, to the extent we've seen regulatory choices inform the application of Article 102 as to what is, for example, an essential facility, or what acts like an essential facility, in order then to find whether blocking access to that was an abuse of dominance. One could argue that the DMA might work that way, although I feel that the relation between the DMA and traditional competition law, as shaped by Article 16A, is a bit different, in the sense that the DMA, as I understand it, acts like the obligations imposed by the DMA act like typical endangerment provisions that one should not infringe, and that entail a sanction irrespective of the proof of a concrete, actual, or likely effect. Then, if the Commission, or indeed a national competition authority, finds that the infringement of one obligation under the DMA has entailed actual or likely anti-competitive effects within a given geographic market, then they can apply either the European or their own national competition law, but that will be only in order to sanction the effect, which has not been sanctioned by the DMA because it is irrelevant under the DMA. so as to comply also with the principle of ne bis in idem. I'm not sure whether you asked an additional question or.
Yeah, I think we have quite a long catalog of unanswered questions. So if you want to pick any, and let me pass the floor to Maria, and then I'll revert back to you, George. But if you have time to examine, Maria, do you want to reflect on any of these issues?
Yes, just to add on the ne bis in idem point that George just made, I think this is a very delicate question and an important one that the DMA regulates in a very discrete manner, in a sense that it tries to underline that the goals of the DMA are different from the ones of the traditional competition law, and one can think then of the case law of the court in B-Post and Nordzucker, that, well, if you have different goals in different regulatory bodies, different regulatory frameworks, then it is potentially possible to sanction a company for the same facts, provided that certain conditions are met, among others, when there is cooperation between the regulatory enforcers, and also clear-cut rules when to predict that a behavior will be subject to which legal framework. I think that in terms of the question, what gatekeepers can do to promote the goals of the DMA, obviously it is a very important task for them, as they are obliged to do so and to follow the rules to ensure that the rules are effectively fulfilled. But there is also a clear message in the DMA that there should be a regulatory dialogue with the enforcer, with the Commission. So I think that this would play a huge role in practice as to how the DMA is understood and enforced, whether it is self-executing. I think the term is not really always very ideal to describe the situation, as obviously there will be some enforcement measures involved too. But in any case, there should be a regulatory dialogue. And maybe also one last point, what also George mentioned previously on litigation to be expected. I think that one important point, which is also somewhat hidden in the framework, is private enforcement. And there are some fears that standalone private enforcement could potentially jeopardize, the functioning of the DMA and the regulatory dialogue. But I doubt that this is exactly what the DMA intends. There is no limitation on any type of private enforcement whatsoever. We only have this provision on the cooperation with courts in Article 39. Then there is also an explicit provision on representative actions regarding collective interests of consumers. So overall, we can see that the DMA is rather open to private enforcement. And in particular, in Germany, this would be a good example to see how private enforcement would work in practice, as recently with the 11th Amendment, the law has extended certain provisions in traditional private enforcement of competition law also to the DMA now.
Thank you very much, Maria. Vivien.
Yeah, I see. I see. George, I mean, he wants to to pick up on some of the thing. No, I mean, I won't get into. I mean, I won't repeat. I mean, what was said, but I mean, you have questions on your list. I mean, how close the DMA to antitrust law? I think, I mean, George underlined the fact that indeed, I mean, we always talk about the new world, and this is not the first time we're talking about the new world. But I mean, the experience tells me that actually you may have a new world, but you have also, I mean, very set principles that we are actually relying on. And this is something that I see when people talk about fairness, for instance, and that was already underlined by George. I mean, this is something that is known. That is something that is not new to us. I mean, we are adapting, I mean, of course, I mean, the principles, I mean, to the facts or to the situation that we have to deal with. But I do not see, you know, a real new world, I mean, challenging the principles on which we rely. So I understand that it's fascinating and exciting to have, you know, a new piece of legislation to, I mean, I really do, and I'm the first, I mean, to be excited. But once again, being where I work, and for my colleagues, I guess it's the same, we know that these new worlds, I mean, came before, and they will come also after. And we're gonna try, I mean, to provide what we are supposed to provide. I mean, legal certainty. So all this, is that okay to limit the scope of addressees to only intermediation service providers? Is that okay to delineate so narrowly? I mean, this is something that we may actually discuss narrowly that you mentioned on your list. So narrowly the scope of core platform services, stuff like that. You know, this is something that we're going to look at with the same type of principles to provide them in this legal certainty. So for the moment, as I said, I mean, I'm quite prudent, of course, I mean, for what I say, but I keep my excitement, you know, towards the future judgment that we will have, and not really, I mean, to what it could change, I mean, completely, I mean, the face of this legal earth.
Thank you very much, Vivien. George, please add to what you wanted to say.
Yes, no, maybe there is only one point, because Maria referred before to the 11th Amendment. From what I understand, the 11th Amendment is a transposition, but please, Maria, correct me if I'm wrong. It is an attempt to transpose parts of what has been going on in the UK since the late 1940s with the market investigations and as a competition tool for finding adverse effects on competition without any infringement whatsoever, but with a regulatory intervention in the functioning of specific markets on the basis of quite an extensive fact finding and economic analysis that underlines or shows directly the existence of adverse effects on competition, and on the basis of those findings, some orders addressed to those operators, to those market actors, as to how to conduct their business in the future in order to eliminate those adverse effects on competition. So, yes, I think that is an export that Britain has, that Great Britain has managed to do despite Brexit to Germany. And let me just say this: at some point, I believe that there was a discussion in very general terms of policy as to whether the EU should adopt a model like the UK one, or rather a more limited model, which would simply focus on digital markets and impose specific obligations rather than grant the Commission the power to conduct market investigations and impose obligations where they find adverse effects on competition. And the EU chose to move with digital markets and impose a series of obligations, but probably precisely in order to eliminate adverse effects on competition as they were found on the basis of the evidentiary basis that was before the Commission and the co-legislators.
Many thanks, Maria. And actually, it demonstrates very well why private enforcement is less. So it's kind of much more in the spirit of the 11th Amendment. The DMA is much more rather than in kind of more remedy oriented. But do you want to comment on what Georgia said?
Basically, I totally agree with George. I just wanted to add that the 11th Amendment has quite a few new provisions, and the implementation of the DMA is one important aspect of it. But then there is also this new competition tool or export product close to the original new competition tool of the Commission and the UK approach. I think that, however, the importance of these two, the practical significance, is very limited. As the president of the Bundeskartellamt, Andreas Mund, has put it on several occasions, it is not really an instrument that will be used on a day-to-day basis. It is really a subsidiary instrument for very specific cases with limited practical relevance. And in a sense, it is the Christmas present that the Federal Cartel Office received that it did not really ask for, because it involves quite a lot of resources. I think the sector inquiry is supposed to take 18 months. And then another 18 months to find the proper measure to apply. Then there are multiple elements that are not really clear cut, where you have very specific legal terms that need to be further concretized in practice, specified, like what is malfunctioning that is persistent and significant of the market. So I think that the practical significance will be much more reduced than the DMA, which is the obviously limited to digital markets, but would be applicable immediately to gatekeepers.
And this is basically why I love these conversations, that it can continue and continue and continue. But I am mindful of your time, and I'm very grateful for the opportunity. Let us finish with brief recommendations to students and those who want to join the club of, let us not call your hidden architects gray cardinals of the system. Vivien.
Right. I mean, there is always a good thing to do, is to do an internship with us. That's the first thing, I guess, we should start with, because that allows, students to come and see from inside, how we do our work here. However, I guess, it's because it's my background as well, but I believe that, no one should, do a career here and stay forever, or actually start here. I believe that when you have to deal, and the discussion we have with the DMA right now is actually quite significant, I believe. You should be mindful of what is going on outside the court, so to know how the economic operator, especially at the general court, works, and their difficulties before judging them. So even if we are little helpers and we do not judge, we have to understand. We have to understand points of views, different points of views, and I believe that having an experience, outside, so from law firms or research, or from working in a company before coming here, and to be for quite some years, a few years. George has been here, for quite some years, myself as well. Maria, has been here also, with us for some years, a few years. I believe. This is something fantastic, but once again, I think it's better understood when you have an experience before, and that is really something I want to underline for people who want to come and join here. come as an intern, then, I mean, see the world with your own eyes, come back and help us, I mean, to do the job that we do.
Many thanks indeed, Vivien. Maria.
I would agree with Vivien that an internship is an important part, but also maybe the language is equally important, as it is not always known that the official language, the working language of the court is French. With a few exceptions for advocates general who can draft also in other official languages. But the first language in which a judgment is drafted is always French. So I think that it is important that this multilingualism is also picked up by actually all legal backgrounds, but in particular also by scholars aiming to focus on EU law.
Many thanks indeed, Maria. George.
I completely agree with both my colleagues on this as well. And Vivien is absolutely right. The work at the court requires some earlier experience, either as a lawyer or as an academic, or both. But it does require that because one should have the sense of one should be able to make a distinction quite clearly between founded and unfounded, and that there is nothing more precious to that than experience, even if, as a lawyer, one must show that they believe in every single plea they raise. This is part of the experience that can be put in value when at the court. And then, of course, the issue with the French language, which is the working language of the court, and having a very good command of both oral and especially written French is extremely important. Or I would say it's a condition sine qua non in order to work at the court as a référendaire, with a few exceptions relating to advocate general who can write originally in another language, of course. But those are quite few, I would say. They're quite limited exceptions.
Thank you very much, George. Vivien Terrien, Mariya Serafimova, George Gryllos, thank you very much for this genuinely interesting and informative conversation. It was a real pleasure for me. Thank you.
Thank you.
Many thanks.